Once upon a time in a segregated Alabama town lived a young black boy named Isaiah Carter whose life hung precariously on the edge of injustice. Accused in a racially charged misdemeanor and brought before the local courthouse where prejudice steered every step of the process. And when his mother sought legal help, no white attorney in town would take his case, forbid even explaining the charges. They recoiled at her presence or refused for fear of community backlash. Isaiah began to believe that the law was a tool of oppression, not protection. Several miles away, a young white lawyer named Samuel Grant was cutting his teeth in criminal defense. Raised in a conservative family, he had been taught to value order and social stability over controversy. In law school, he avoided cases involving race, believing they were futile fights in a system built against people like Isaiah. That changed the day he met Morris Dees' own story. As a new attorney, he had once defended a Ku Klux Klan member pro bono because no one else would, a case he later said gave him an epiphany and regret, and inspired him to dedicate the rest of his life to civil rights work. Turn 1 Search 23. Grant read about that in Dees' autobiography. That moment of refusal turned insistence had unleashed a deep moral transformation in Dees and led to his founding of the Southern Poverty Law Center. Inspired, Grant began rethinking his own path. Meanwhile, Isaiah sat in jail on forged testimony, his future bleak, until his family managed to locate Grant in a county directory and begged him to take the case. At first he hesitated, conscience battling fear of backlash, fearing clients and colleagues would see him as radical. But something in Isaiah's eyes reminded him of Dees' regret, and Grant reluctantly agreed to meet. In the interrogation room, Isaiah told his version calmly but firmly. Racial profiling, coerced admission, no real evidence. Just a community's rush to judgment against a poor black teenager. Grant listened, uneasy. He asked, "Why are you the only one willing to listen?" Isaiah shrugged, "Because here I am." The room reeked of stale humidity and fear, but in that moment a spark ignited within Grant. He agreed to represent him, despite local attorneys whispering behind his back that he was becoming that lawyer. Grant studied case law on coerced confession, racial profiling, and prosecutorial misconduct. He collected witness statements, challenged Miranda waiver validity, demanded scientific evidence, but the weight of local prejudice pressed over him. He rode Tuesdays to the courthouse with documents, deposition requests, and motions to dismiss, but judges refused hearings, prosecutors delayed evidence, and jurors assumed guilt. Grant found allies in rare civil rights groups and young lawyers who recalled Dees' path from defense of Klan clients to champion of civil rights. Together they filed motions invoking equal protection claims and demanded a detective recuse when racial slurs surfaced in paperwork. Grant's law school debt, his social standing, even his sense of professional identity were on the line, but every mockery and threat only steeled his resolve. Isaiah's mother organized protests at the courthouse steps. Local newspapers began asking why no lawyer dared support the accused boy. National media picked up the Dees connection, interviewing Grant about the dilemma. Why represent a black teenager in a racist town? Grant said simply, because no one else would. As the trial date neared, evidence emerged. The lead witness admitted to being paid by a bail bondsman, the supposed owner of the alleged damaged property recanted, and a recording surfaced that contradicted the confession. Isaiah's jail door swung open after bail was posted by a civil rights nonprofit. At the courthouse the morning of trial, Grant delivered opening statements that wove the youth of the accused, the racial undertones of the charge, the absence of real evidence, contrasting local prejudice with constitutional guarantee. The judge, after 2 days of testimony, granted a directed verdict of not guilty. Isaiah wept free. The courtroom fell silent. This moment shifted everything. The attention of attorneys across the state, grants from national legal defense funds, and a cascade of speaking invitations that branded Grant as the lawyer who would represent the black child in a racist town when everyone else refused. But with visibility came backlash. Local clients dropped him, bar association members hinted he was becoming too political, and he lost his position at the local chamber of commerce. Still, he opened a legal clinic for civil rights cases, helping indigent clients challenging racial profiling, voting suppression, and police misconduct. He built a reputation akin to Dees's, but more rooted in small-town courage. And then came the call that would define his career. A church bomb survivor seeking justice after being refused representation by multiple firms citing risk. Grant felt the same hesitation, A powerful church, powerful suspects, huge stakes. But when he looked in the survivor's eyes, he recognized his own turning point. He booked the meeting. He opened his case file. He felt every risk, and every moral imperative. And as he stepped into the church's battered sanctuary to meet with the victim, he saw on the wall faded photos of victims of racial terror, and realized, this case could break the town's silence or break him. Don't forget to like, comment, and subscribe for more powerful stories that uplift Black voices and expose hidden truths. Once Isaiah Carter walked free from trial, acquitted in a racist town where no lawyer would represent him, the moment reshaped his life and the trajectory of Samuel Grant. Grant filed formal police misconduct complaints, appealed a furiously dismissed public defender denial, and began receiving calls from Black families across the county, accused children with coerced confessions, elders arrested in traffic stops, churchgoers targeted at protests. He founded the Carter Grant Legal Defense Clinic as a hub for indigent clients and civil rights cases. The local bar council ostracized him. Invitations dried, phone calls stopped. Still, every time he hung a new Justice Clinic sign outside his office, he understood the sacrifice. He built relationships with the NAACP Legal Defense Fund and found guidance in the legacy of Morris Dees, the Alabama lawyer who once defended a Klansman pro bono and later regretted it, who used that awakening to found the Southern Poverty Law Center, SPLC, and shut down powerful hate groups through civil lawsuits. Grant saw Dees's arc in his own story, from reluctant local criminal attorney to affirmative defender of the marginalized. In the clinic's first year, they handled wrongful convictions, voting rights challenges, and false imprisonment cases, but nothing as pivotal as the call from a survivor of a church bombing in a neighboring county. Dozens of families had been denied representation. Powerful local lawyers refused to take the case. The survivor had scars, physical, emotional, and faith that no justice would come without a lawyer willing to endure threats. Grant traveled to meet her in the sanctuary, now a charred ruin, with supporters standing vigil. He reviewed medical records, FBI reports showing evidence of racially motivated arson, and depositions where bail bondsmen and deputies admitted procedural violations. The entire town was hush around the case, fearing reputational fallout. Grant knew a federal hate crime prosecution might proceed, but was in short supply of local counsel willing to represent the victim in civil suits. He promised to press forward. Meanwhile, firearms license check logs and state evidence files revealed the suspected bomber held local office connection, suggesting a cover-up. As Grant and his small legal team worked, he drew analogies to the Scottsboro Boys case. 9 Black teens falsely accused and denied fair trials in the 1930s Alabama, their struggles against lynch mobs and rushed trials forcing new standards in due process and representation. Like the Scottsboro defense attorneys who risked reputation to challenge all-white juries and rushed indictments, Grant now stepped into a fraught terrain of racial terror, legal resistance, and community outrage. He filed federal civil rights complaints under 42 U.S.C. Section 1983 for conspiracy to violate constitutional rights, First Amendment claims for suppression of witness testimony, and Bivens claims for law enforcement misconduct. Local newspapers reacted. The county sheriff's department issued a statement hinting that outsider lawyers were stirring unrest. Clients shivered at the daily intimidation campaigns. Unknown callers threatened symbolic violence. Yet surveys from the Equal Justice Initiative show contemporary Alabama communities still bear scars of past racial terrorism and often fall silent when survivors seek redress. Grant pressed on. In federal court, the bombing case was assigned to a judge with a record of acknowledging racially motivated state misconduct. Grant's opening brief referenced powerful civil judgments that targeted Klan-affiliated organizations via civil liability, like SPLC victories awarding millions to Black plaintiffs injured in hate crimes. The judge scheduled oral argument. As the date approached, Grant spoke at HBCU campuses, sharing his journey from reluctant lawyer to civil rights defender, telling students that when the law refuses the marginalized, someone must step into the void. His clinic's modest funding expanded, donors rallied, media picked up the story, the lawyer who defended the Black boy no one else would. But as the bombing case gained traction, his firm landlord got pressure from conservative clients to evict him. Bar associations whispered ethics inquiries about political activism and civil work. His phone buzzed with an encrypted note from the sheriff's office, "We're watching." The night before oral argument, Grant sat alone in his office, reviewing deposition transcripts of law enforcement officers who misfiled evidence and withheld medical treatment to coerce statements. He framed constitutional torts: malicious prosecution, deliberate indifference, discrimination under equal protection. He practiced his argument aloud into a recorder. Justice denied is justice deferred, but justice delayed in systematic racial terror is denial of citizenship itself. He set alarm for dawn, then checked his email. 2 messages unread, one from the presiding judge with scheduling details, another titled, "Immediate, your law license reviewed." He felt his heart pound. Does justice demand I risk everything, or do I step back and let another lawyer lead? Below, a storm raged outside, raining against streetlights. And as he leaned toward his laptop to open the secure message, the office power flickered, and the phone began to ring. Don't forget to like, comment, and subscribe for more powerful stories that uplift Black voices and expose hidden truths. Once Isaiah Carter walked free, Samuel Grant's commitment to justice expanded beyond one child's fate. His Carter Grant Legal Defense Clinic became a beacon for Black families across the region. Cases involving coerced confessions, voting suppression, police misconduct. And with each file signed, his reputation grew as the only local lawyer brave enough to stand against systemic bias. The hometown bar and civic organizations turned cold, invitations vanished and threats followed. But he leaned into history, drawing on the ethos exemplified by Morris Dees, who famously represented a Klansman early in his career and later expressed regret, using that epiphany to found the Southern Poverty Law Center and sue hate groups into bankruptcy, securing verdicts like $7 million against the United Klans of America after the lynching of Michael Donald. Grant saw in Dees a parallel. Someone who once refused and then fought, someone whose moral standpoint resonated in the face of community scorn. When the call came from a survivor of a church bombing in a neighboring county, whose family had endured humiliating refusals from law firms fearful of backlash, he felt the same tidal pull of conscience and dread. He traveled to a charred sanctuary, reviewed medical reports and FBI files that pointed to law enforcement negligence and possible cover-up, and sensed the quiet complicity of townsfolk siding with silence. Evidence included lead investigators tampering with license check logs and first responders refusing care. A civil rights crisis reminiscent of the Scottsboro Boys case, when 9 Black teenagers were wrongly accused, denied competent counsel and tried before all-white juries, later leading to Supreme Court rulings such as Powell v. Alabama and Norris v. Alabama, which affirmed the right to counsel and banned systematic racial exclusion from juries under the 14th Amendment. Grant drafted Section 1983 civil rights suits against law enforcement, First Amendment claims for suppression of witnesses, and constitutional torts reflecting deliberate indifference and malicious prosecution. But as he prepared for federal court, covert pressure mounted. The local sheriff's office warned him via encrypted message that outsiders were stirring unrest, conservative donors threatened to pull clinic funding, and ethics committees began questioning whether his activism exceeded permissible boundaries for practicing attorneys. Media attention spiked when statewide outlets ran features calling him the lawyer who defended the boy no one else would, comparing his courage to Dees's legacy, yet the local bar's leadership leaked inquiries into his fitness to practice civil litigation. The judge assigned to the bombing case, a jurist known for ruling against racial bias in public institutions, scheduled oral argument. Grant rehearsed, weaving constitutional claims, historical injustice parallels and moral clarity, speaking into a recorder. Justice delayed is justice denied, but justice deferred in the court of race is denial of citizenship itself. That night, financial supporters pledged emergency pro bono assistance. HBCU students invited him to speak. Nascent donors funded a trust for survivors. But threats came too, anonymous letters to his landlord threatening eviction, and an email to the bar from an unknown sender alleging political activism disguised as legal work. As he prepared to sleep in his office under files and glowing desk lamp, his screen lit with 2 urgent messages, one from the federal courthouse confirming tomorrow's hearing date, the other titled Bar Committee, Informal Inquiry re, Your Civil Rights Cases. The lights flickered outside, thunder rolled, and he stared at both subject lines, knowing that at sunrise his life would be divided, in the courtroom confronting injustice, and before the bar confronting his own professional survival. He reached for the courthouse message, and the power went out. Don't forget to like, comment, and subscribe for more powerful stories that uplift Black voices and expose hidden truths. Samuel Grant stood before the federal courthouse on the morning of the bombing case oral argument, the Carter Grant Legal Defense Clinic's small banner fluttering behind him as supporters and media gathered. Despite rising local opposition, his momentum was unstoppable. He built his opening argument on Section 1983 constitutional torts for racial terrorism, equal protection violations, malicious prosecution, and deliberate indifference, grounded in history and law. He invoked Powell v. Alabama and Norris v. Alabama, Supreme Court decisions from the Scottsboro Boys saga that affirmed a Black defendant's right to counsel and the unlawfulness of excluding Black jurors as unconstitutional violations of due process and equal protection. Grant framed the church bombing not just as arson but as a modern echo of that era's terror, racial violence used to silence Black citizenship, and he demanded accountability from sheriffs, deputies, and county officials whose misconduct had allowed the attack and obstructed justice. Inside the courtroom, the judge listened as Grant described the conspiratorial tampering with license logs, the suppression of witness testimony, and delays in medical treatment, acts consistent with constitutional violations under Bivens and Section 1983. He called on jurors to recognize the pattern of racial terror and state collusion. As he spoke, the packed courtroom felt the energy, survivors nodding, supporters tense, and lawyers from other regions watching. Then, the firm's landlord publicly declared intentions not to renew Grant's clinic lease, citing fears stirred by outside activism. Bar leaders anonymously circulated allegations that Grant's civil rights work violated rules on political neutrality and risking local stability. Despite these signs, Grant pressed on, confident the legal precedent and moral underpinning of his arguments would prevail. In closing, he made the case personal, recounting how no local lawyer would defend Isaiah Carter, how families had been silenced until he intervened, and how history demanded someone stand up. Justice delayed is justice denied, he told the judge, echoing a refrain first used decades earlier, and asked the court to restore dignity to the survivors and accountability to local institutions. The next morning, as he walked back to his office, his phone rang with an encrypted message from the Bar Association. Informal interview requested regarding your political activity in litigation. At nearly the same moment, a second message arrived from the judge's clerk. Court ruling issued, please review order. He opened the court's docket and read. The judge granted a preliminary injunction ordering the local sheriff's department to produce internal records and scheduling a trial on compensatory and punitive damages. Grant exhaled, but before he could breathe relief, he opened the bar email. The bar's tone was grave, inviting him to explain whether his clinic's public advocacy breached ethical duties of neutrality and whether he had impermissibly mixed politics with litigation. He realized, sweeping victory in court could become professional ruin. Back in his office, he paced between piles of evidence and legal briefs. A storm began outside, lightning flashing over courthouse spires. He knew that in federal trial he could force institutional transparency and win justice. But in the same breath he faced a potential ethics proceeding threatening his license. He reached for two phone numbers. One dialing an ethics lawyer familiar with civil rights defense, another dialing his clinic's board chair, whose voice he needed to rally new funding and moral support. The wind howled as he considered how to defend both court and career in parallel battles. Not just for survivors but for his own survival as a civil rights attorney. Then his phone buzzed again. A third email arrived, subject line, anonymous complaint filed with State Bar, potential suspension proceeding. Grant looked out at the courthouse under the storm-dark sky and knew the next move could change not only the bombing litigation but the entire story of who gets to practice justice, or be silenced. He turned on his phone flashlight, illuminating a secure document. Bar complaint allegations, accusations that he improperly courted media attention, politicized legal strategy, and endangered the clinic's neutrality as counsel. He swallowed hard. All at once, court victory and professional peril stood side by side. And as the lights flickered with thunder above, he prepared to decide, fight both battles, or risk everything. Don't forget to like, comment, and subscribe for more powerful stories that uplift Black voices and expose hidden truths. Once the federal judge granted the clinic's motion in the church bombing case, ordering production of sheriff's records and setting a trial for damages, every step in Samuel Grant's journey seemed to converge. the courtroom vindication, the survivors' hopes, and the legacy of justice he upheld. But standing parallel to that legal victory were whispers of discipline, swirling bar complaints, and opaque threats to revoke his right to practice law. Grant convened with his ethics counsel and civil rights funders. They advised that political advocacy, even if intertwined with legal strategy, must be clearly separated from courtroom work to avoid violating professional neutrality rules. This was no mere hypothetical. Civil rights lawyers like Rudy Narayan in the UK faced disciplinary hearings for bringing the justice system into disrepute through public accusations of systemic racism. Though he was later acquitted, his case highlighted how thin the line can be between ethical advocacy and professional risk. U.S. regulations similarly guard against overly political litigation that might appear to leverage cases for public attention. Attention raised in state bar court discussions over First Amendment protections versus preserving the integrity of the justice system. Grant drafted a clear plan: keep civil litigation focused only on constitutional claims, separate his clinic's public campaigns into a non-profit layer, and steer media engagement through third-party spokespeople. He filed responses with the bar, emphasizing that his civil litigation was rooted in rule of law principles and constitutional guarantees, not partisan agitation. Meanwhile, he coached his clients. Their stories were painful, but the courtroom is not a soapbox, it's a forum for truth and accountability. In the courtroom trial, Grant called survivors, forensic experts, and witnesses. Testimony revealed how deputies botched crime scenes, suppressed warnings of imminent harm, and failed to pursue credible leads. The jury heard about racial terror in modern form: a congregation attacked, authorities complicit, justice stalled. When Grant spoke, his voice did not tremble but carried years of resolve. These survivors were denied dignity. They were denied help. Today, the law will demand accountability. He won a landmark judgment: compensatory damages for survivors, punitive damages against the sheriff's department, and a permanent injunction reforming county procedures for investigating acts of racial violence. The ruling was praised in legal journals and drew comparisons to SPL-Sierra wins that dismantled hate group power through civil liability, like the multi-million-dollar verdict against the United Klan and later SPLC bankruptcy strategies. The survivors cried at the verdict. Grant shook hands with families who had long been silenced. But outside the courtroom victory, the ethics and personal storm grew denser. The bar still questioned whether his dual roles, as local attorney and public advocate, violated rules on maintaining neutrality and avoiding political influence. Bar counsel requested hearings to assess whether his media involvement improperly shaped litigation strategy or risked undermining the firm's independence. Grant's colleagues at the clinic were divided. Some urged caution, others praised his unwavering moral clarity. Then came the final blow: an official notice that the state bar would hold a formal disciplinary hearing to determine if he should be suspended or censured for mixing public activism with litigation. The notice cited complaints of politicizing civil rights litigation for public attention, a phrase repeated in letters from conservative donors and bar insiders uncomfortable with his prominence. At the same time, national civil rights organizations invited him to testify before a congressional committee on state-sanctioned racial violence, an invitation he couldn't refuse, and the news made headlines. Public opinion rallied. Legal commentators referenced Hensley v. Eckerhart and 42 U.S.C. Section 1988 fee statutes, pointing out that civil rights lawyers who secure meaningful victories for systemic injustice are often awarded attorney fees, underscoring courts' support for public interest litigation. Grant faced two courts: the federal jury, who had vindicated survivors and affirmed justice, and the professional bar tribunal, which threatened to end his legal career. In the quiet of his clinic office, files stacked, he stared at the notice and then at his client photos on the wall. Isaiah Carter's childhood image, the church survivors, the faces of communities once silenced. He realized the final choice: challenge the disciplinary proceedings, risking public trial of his motivations, or step down quietly, protecting his license but silencing his mission. And standing at that crossroads, he drafted a message to the bar tribunal. He would defend his role as both advocate and lawyer, but warned that dismantling his civil rights work would send the wrong message, that lawyers of conscience must choose between serving justice and keeping their licenses. He pressed send. When the legal system fails the marginalized, someone must step forward, even if it means risking everything. Justice sometimes demands more than victory in court. it requires courage outside of it. Lawyers who refuse to remain silent in the face of discrimination challenge not only injustice, but also the structures that punish principled dissent. This is the moral of Samuel Grant's journey. If you want true justice, you must be willing to face not just the courtroom, but the consequences of standing for truth. The end. Don't forget to like, comment, and subscribe for more powerful stories that uplift Black voices and expose hidden truths.